Good afternoon, everyone. Welcome to HHQ webinar. We are glad to have many esteemed attendees with us today for our webinar on rescheduling and restructuring of loan facilities and recovery actions. My name is Teo Zihan, pupil in Chambers of Halim Hong and Kwek, and I will be the moderator for today's session. Before we kickstart this session, please be informed that all participants must be muted, and if there are any questions, please type in the Q&A chat box and we will discuss them during the Q&A session later. Please allow me to introduce our speakers, Ms. Teo Siang Lee and Mr. Lam Man Chan. Ms. Teo Siang Lee is a partner of Halim Hong and Kwek, specializes in the corporate banking and corporate and commercial. Her knowledge and expertise in the corporate banking field are put to good use when she advises a variety of banks and financial institutions on a broad range of legal issues, all ranging from loan and security documentation to compliance-related matters, requirements, and procedures. She excels in local and offshore bilateral and syndicated credit facilities for financial institutions and corporate borrowers. Our second speaker, Mr. Lam Man Chan, also a partner of Halim Hong and Kwek. His practice mainly revolves around corporate litigation and critical matters such as liquidation and restructuring, debt recovery, insolvency, and employment disputes. So, please join me to welcome our speakers, Ms. Teo Siang Lee and Mr. Lam Man Chan.
Hello, good afternoon, everyone. Thanks for joining the sessions today. My name is Teo Siang Lee. As introduced by Zihan, I will be giving the sharing on the loan rescheduling and restructuring and recovery actions by today. So let's allow me to do a share screen on my slides today. The topic to be discussed today will be on the rescheduling and restructuring of loan facilities, financial assistance provided by government in light of pandemic. For the debt restructuring part, I invited my partner, Mr. Lam Man Chan, to give a talk about judicial management, scheme of arrangement in respect of the companies pursuant to the debt restructuring. Then I will continue with the limitation period, as well as the enforcement of securities and recovery actions. Let's look at the first part, rescheduling and restructuring of loan facilities. When it comes to rescheduling, basically the simple way of rescheduling is extending or lengthening the loan tenure. So when we extend or lengthening the repayment loan tenure, it will result in a revisions of our monthly installment amount. That borrower, after the rescheduling, will be paying a lesser sum each month, meaning they will lower down their monthly commitment. So when the borrower is paying lesser sum each month, it will eventually result in paying more interest, because along the way, when the repayment period has been lengthened, the interest they are generating may be even more. So when it comes to rescheduling, it's like you are lengthening the whole loan repayment tenure period. It will result in lesser commitment each month, but at the end of the day, there might be the issues that interest that the borrower is serving is actually even larger. But when it comes to restructuring, it involves changing the type and structure of the existing loan. That may help to improve the borrower's current cash flow or other, but there are more significant changes to the terms and conditions of their existing loan as compared to rescheduling. In terms of restructuring, it may convert the overdraft facilities into a term loan facilities, or it may convert or consolidate certain types of facilities into one term loan facilities. So when it comes to restructuring, it may involve more significant changes to the terms and conditions of the existing loan, and it may incur additional admin charges, legal costs, or may incur further stamp duty if there is any. Be it a rescheduling or a restructuring of a loan facilities, the borrower may be required to execute an instrument to reflect the changes in exercising a rescheduling or restructuring. If let's say there is a purely lengthening of a loan tenure, the borrower may just need to sign a supplementary letter of offer. But whereas when there is a restructuring, the borrower may require to execute additional or supplementary loan agreement, or the borrower may also be required to provide any further security documents for the additional loan sum or other instruments that may be imposed by the bank. If there is any additional loan sum that the bank is granted to the borrower may be subject to further stamp duty, which is an ad valorem stamp duty. In general, the bank will still favor rescheduling and restructuring as a form of aid by helping the customers to improve the bank's resilience and reducing any non-performing facilities portfolio, as well as maximizing the credit recovery. Yeah, as requested by some of the participants that actually requested us to give a summary in Mandarin, I would suggest that maybe by the end of each part, I would just give a brief summary in Mandarin. Yeah. So for rescheduling, 这里我会觉得 rescheduling 是一个重新安排。重新安排就意味着你会延长你整个贷款的期限，延长贷款的期限，同时它会调整每个月我们需要月供的这个供款额，所以每月的负担相对来说是会减少，对不对？对财务的这个 management 来说是有相当的有一个喘息的空间，但是由于这个贷款的期限更长了，因为你延长整个贷款期限，它也会导致我们需要付的更多的利息。然而，在这个 restructuring 它是一个重组的模式，所以重组来说呢，它会涉及更换您现在原有的这个贷款的这个类型和架构，以助改善这个现金流。所以，比如说，你可以将你的透支的款额全部都把它转换成一个定期的付款，这样子的话，它是一个重组的模式。但不管你是重组还是你是重新安排都好，也许有一些其他的费用，也包括说，如果你有额外的印花税、额外的律师费等等，都是需要这借款人这边支付的。The next one is the financial assistance provided by government in light of COVID-19 pandemic. So I just share with you the recent announcement made by the government is the 6 months loan moratorium. This 6 months loan moratorium is now available to all individuals, be it your B40, M40 or T20 and micro enterprises and affected SME. The applications can be made starting 2 days ago on the 7th July 2021. This is without imposing any conditions. So you don't have to give a proof for the reduced income or job loss. But this moratorium is a bit different from the moratorium last year. Moratorium last year, it was an automatic, but moratorium this time, you will need to make an application to your respective banks. But you just need to go to your respective bank's website and just follow the procedures in order to get the automatic loan approval. So this round, there's no supporting documents required, but for the SME, which is adversely affected by the pandemic, you will need to provide a self-declaration. Yeah, these are the individual group based on the household income. I just take it from the Department of Statistics Malaysia, the B40, M40, and T20. This 6 months loan moratorium is applicable to all individuals as well as micro enterprises and SME. So how to get this 6 months moratorium? This is an extract from the website of Bank Negara Malaysia. You will need to go to your respective banks to check into their website and to fill in an applications. So the bank will process the applications within 5 calendar days for the individuals or 14 calendar days for the micro enterprises and SME. But this loan repayment will not affect any of our secrets record. 所以在这是一个6个月的一个偿还贷款计划，也是政府刚刚推行的。就在我们2天前7月7日，所有的只要你是个人贷款，不管你的收入是在任何一个阶层 B40、M40、T20， 就是低收入、中等收入或高收入群组等，你都可以向你自己的银行做出这个申请。但是这一次的这个申请moratorium 它不是一个自动的，你得需要申请，但是申请是不需要给任何的附加条件，它是无条件批准的。 The next part, we'll talk about debt restructuring, which I will invite my partner, Mr. Lam Manchan, to give a sharing on the debt restructuring. Manchan, I hand the floor to you.
Hi, afternoon, everyone. So my part, I'll be discussing corporate rescue mechanism under the Companies Act 2016. So as shared by Xiang Li earlier, the government, in recognizing the impact of MCO, the Movement Control Order, has provided 6 months moratorium on bank loans. So with this assistance to ease the cash flow, it is hoped that the company will get back on their feet again in 6 months. But what if it were not so? So the real challenge actually comes when the loan repayment moratorium has ended, but the companies have not been able to resume their business in full force, considering various MCO imposed by the government. So in such case, the companies will face the pressure of paying their creditors when the revenue stream continue to be severely affected, and ultimately they may still find themselves in a precarious financial position. Okay, and this is where the companies may resort to the corporate rescue mechanism under Companies Act 2016. Okay, in the gist, the corporate rescue mechanism gives an opportunity to the companies in financial distress to rehabilitate itself as an alternative to liquidation. So from a creditor's point of view, knowing that your debtor resorting to corporate rescue mechanism is definitely not good news, because it means that restructuring or compromise of debt is almost certain. But however, the hope in here is that if the restructuring plan works well, the sum recoverable from the debtor company may be higher compared to if it is put into liquidation. So subject to different scenarios, the available options to company in distress are corporate voluntary arrangement, judicial management, and also a scheme of arrangement. Okay, I'm moving to the next slide. So for the purpose of reaching a debt compromise with its creditor, so all these three methods of corporate rescue mechanism works in a way where a creditors meeting will be held for the creditors to consider a proposed restructuring plan. Okay, so in that creditor meeting, a creditor will get to vote in favor or against the said plan. But however, in the event the restructuring plan is approved by at least 75% of the total value of the creditors, the plan will be binding on all other creditors, even if such creditors voted against it. So this is the mechanism that we are talking about. But however, all these three methods of mechanism that have different features in terms of their eligibility, processes, and also length of moratorium. Okay, so for an example, in the case of corporate voluntary arrangement, CVA, a nominee will be appointed by the debtor company. And in the case of judicial management, a judicial manager will be appointed by court. I mean, of course, both of them function to propose and also implement the restructuring plan if it is approved ultimately in the creditors meeting. But in the case of scheme of arrangement, the debtor company can propose and implement the restructuring plan themselves without interference by a third party. But of course, this is under supervision of court. So ultimately, in the event that the restructuring plan has been approved by the creditors, I mean, it still needs further sanction from the court. Okay, so I will touch on most important point, which is on this moratorium, because ultimately as a creditor, this is what affects the creditors the most. Okay, so when the moratorium is in place, a creditor is not allowed to take any legal action against the debtor company, but of course that was subject to leave by the court. And why this moratorium is important for the company in distress is because it would allow time for the rehabilitation exercise to develop, which might preserve the value of the company as a going concern. Secondly, it can put a brake on the legal costs and also the associated costs. And also, it also gives the creditors time to consider their position for the purposes of the creditors meeting. And last but not least is to prevent creditor from obtaining any advantage over other creditors. So these are the reason why the moratorium is important. Okay, so moving to next slide. Okay, we are looking at the length of moratorium for these three methods. So for example, for CVA, the corporate voluntary arrangement, once filing the application, the company will get an automatic moratorium of 28 days. And whereby, I mean, of course, in this period, no one can sue them. and everything puts to a stop. And this period may be extended up to 60 days, subject to approval at its creditors meeting. So they need the consent of the creditors for them to be entitled to a longer moratorium. So next, I will look at the judicial management, where upon filing of a judicial management application, the company will get an automatic moratorium. Okay, but however, this moratorium is not a full moratorium. Okay, and if in the event the court allowed such judicial management application, okay, the company might be entitled to a further 12 months of moratorium, subject to court's approval, of course. So third, we will look at the scheme of arrangement. For scheme of arrangement, there's no automatic moratorium, but the company, after or before making the application for a scheme of arrangement, okay, they may also apply for a restraining order. So the time limit for this restraining order is that the court may grant RO, required RO of up to 3 months, and maybe a further extension up to 9 months. Okay, next we will look at creditors' recourse in terms of all these three restructuring methods. For an example, for CVA, it is not available to companies with charge. So in short, all the creditors in a company doing CVA is, of course, they are all unsecured creditors. And because this CVA is designed to be management driven and without much interference of court, so the creditors' recourse actually lies in the creditors' meeting, because there's no express provision to challenge the restructuring plan. Okay. In opposition, for an example, judicial manager. Okay, a creditor may intervene and oppose judicial management application, and because of subject to public interest, the court may, the court shall dismiss a judicial management application if it is opposed by a secured creditor. This is clearly stated, a secured creditor. In the event a secured creditor opposed to a judicial management application, the court is actually obliged to dismiss such application. But of course, there's an overriding factor of public interest which the court may consider. Okay, so similarly, for scheme of arrangement, a creditor may also intervene and oppose the convening of a creditors meeting or class composition fixed by the debtor company. Okay, this is what the creditor can do at this stage. Yep. I think that would be all for my sharing. Handing back to you, Sang-Lee.
Okay, thanks, Manchan. Yeah, let's move on to the limitation period. So the next part of the recovery actions, let's talk about limitation period. When it comes to limitation period, there are two parts. First thing is limitation to bring an action against the debtor. This happens when there is a borrower's default, how long there is a time frame that allow the bank to take an actions against the borrower upon default. The second part is the limitation period for execution of a judgment against the judgment debtors. The second part is when a judgment has already been obtained, but how long can the bank enforce the judgment? So when it comes to a limitation to bring an action against the debtor, the limitation is a period allowed by law for a person to bring a legal action against another. So the limitation period is 6 years from the cause of action accrued. When does this cause of action accrued? The cause of action accrued in terms of a financial breach, there will be the due date of the payment. So from the due date of the payment, there will be a 6 years from the due date of the payment for the bank to commence a legal action against the debtor. Whereas for a limitation to execute a judgment, this is where the bank has actually taken actions against the borrower and the bank gotten a judgment. But once the judgment obtained, if let's say the judgment debtor still refuse to make the payment or still refuse to pay in accordance with the judgment, so what is the next step that the banks can do? The banks will have a paper judgment. The next step will be to enforce the judgment. So here there is a limitation period set in, which is the 12 years from the date of judgment. If let's say the banks wants to enforce the judgment, it has to be done within 12 years from the date of judgment. Otherwise, the judgment will be no longer valid. So a leave of court is required to be obtained after 6 years from the date of judgment. Limitation 是一个时效期，它也可以叫一个诉讼的时效期。当然，刚才所看到第一个 part 就是 limitation to bring an action against the debtor， 就是银行可以对这个债务人提及诉讼的时效，就在这个付款到期的时限的时候，银行有一个6年的时间，在付款到期的时限向这个借款人采取法律行动。然后第二个时效期呢，就是执行那个裁决。如果银行在拿到裁决过后，这个债务人呢还是不肯偿还所欠的债务的话，银行能够做的就是一定要执行这个裁决。在执行裁决的这个时效期是一个12年，从拿到裁决的那一天开始。The next part is the recovery actions. So recovery actions I segregate into 2 parts. One is the recovery of a secured debts, and the other one is the recovery of unsecured debts. Why do we talk about secured debts? Meaning when the loan is granted, it comes with security, so we call it secured debts. So these are the most common securities required by the bank in giving a facilities. So there will be a debt secured by charges, which is your property or land, secured by your leaseholder caveat, debenture, guarantee, or your memorandum of fixed deposit and letter of set off. So I will just briefly go through one by one. The charges by land and property is the most common and most powerful charge. I would say is the most powerful security, because when there is a land charge to the bank or there is a property charge to the bank, so the bank always have a right to get an order for sale, is a foreclosure proceeding to auction the property. So in order to auction the property, the first thing you have to go through the process either in the High Court or in the land office to get an order for sale before the bank can proceed with the auction. Yeah, bearing in mind, once you have made an application and an order for sale is made, the order for sale is granted by the court or the land office, the property can no longer be sold by way of private treaty. It has to be sold by way of auction. Second thing is the liens. Yeah, liens is another securities when sometimes the securities given maybe the bank can just lodge a liens holder caveat. When there is a liens holder caveat lodged, the caveat itself will still endorse on the title and the original title will be deposited with the bank. But bearing in mind, if let's say we are lodging a liens holder caveat, the liens holder can't just foreclose the property as if you just get an order for sale. The procedures is that the bank has to still go to the civil judgment, get a judgment from the court, and once you get a judgment of the court, then only you can get an order for sale in order for the property to be auctioned. Yeah, debenture is one of the most common facilities, one of the most common security that are available in most of the facilities granted by the bank nowadays. So when there is a debenture and the debenture confers the rights of the debenture holder to appoint a receivers and managers to manage the affairs of the company. So if there is any default by the borrower, the bank will have the right to appoint a receivers and managers by way of instruments, which is under the debenture itself, in order to go in to manage the affairs of the company. So what are the powers of the receivers or managers, including they can dispose of property and all these things will be under the statutory of our Companies Act 2016. These are the most common security as well is a guarantee. Be it individual guarantee or corporate guarantee, guarantee is an agreement to pay money on the borrower's default. So usually, although there is a guarantee given by individual or by a directors or by the corporate guarantee, company guarantee, the usual way to enforce a guarantee is that the bank has to issue a letter of demand to the guarantor and to be sent to the guarantor's address, their latest address in accordance with the guarantee agreement or any other, your latest known address. So the procedures are still the same. The lender still has to get a judgment from the court before you can proceed to enforce a judgment and to get the payment from the guarantor. If let's say when you serve a letter of demand on the guarantor, but the guarantor still refuses to pay, then the next thing you still have to go to get a judgment from the court. Yeah, these are also quite common security, the memorandum of fixed deposit and letter of set off. If there is a fixed deposit account, which will usually maintain with the lender, at the same time, other than a pledge, a memorandum of deposit, the lender will require the borrower to sign a letter of set off. So in case there is any default, the lender will have the right to set off based on that. You just have to set off against the account, which the account is maintained with the bank. just give a brief summary. So secured debts 是指这个借款是有担保的，借款有担保，担保可以分成很多种。这边我所提到的呢，就是最常见的担保。担保可以包括就是房屋担保，房屋担保、土地担保的话是一个最有效，跟就可以说是最值得的。如果有一个房屋或者是土地担保的话，银行可以在这个借款人未能履行他借款合同的条款，未能支付他的这个借款的款项的时候呢，可以拿一个拍卖令，拿到拍卖令过后就能够拍卖他的房产、他的土地。Leaseholder caveat 呢，这边我看到是叫留置权。这个 Leaseholder caveat 其实它也会注册在那个我们的土地的地契，但是虽然它有注册在土地的地契，但它跟 charge 它跟那个质押是不同等的，所以就算有一个 leaseholder caveat 都好，还是得到法院拿一个裁决，裁决过后呢，才能够申请这个拍卖令。Debenture 是一个债权，债权呢就包括公司的那些资产，它可以是流动产。machinery, equipment 动产等等，但这个债权的本身就是，如果这个债权的合同书里头有给这个银行一个权利，他可以去申请这个委任 receivers and manager，receiver and manager 他们就能够进入那间公司，然后去帮银行 manage 那间公司，所以这个 receiver and manager 他们有他们指定的这个权利，他们的权利是在我们马来西亚的 Companies Act 里头。会有说明他们能够对这个公司里头的资产做任何的事项。下一个是 guarantee 担保的话，可以是个人担保还是公司担保。不管你是个人担保也好，公司担保也好，其实在银行的角度来说，如果是有欠款的话，第一件事情就是向这借款人，我们会发出我们的律师函追溯那个借款的款项。但如果是这借款人还是不肯缴付这欠款的话，下一步呢，银行就会向这个 guarantor， 就是担保人、担保公司索取那个借款。但是如果担保人呢，还是对这收到律师函还是去到法院过后都是不肯支付这个借款人的欠款的话呢，下一步要去的就是还是得到法院拿一个裁决，裁决过后呢，有了一个 judgment， 下一步呢才能够刚好会有下一个就是 enforcement， 就如何去执行这个裁决。这个我想是一个定期存款，还有你有一个抵销函。如果有定期存款的一个户口，还有一个抵销函，这就很方便。你可以直接有一个 letter of set off， 就是那抵销函，将这个欠款人如果银行户口有钱的话，是可以直接抵销的。So when it comes to recovery of unsecured debts, meaning to say the debts, the loan given is without security, unsecured, then you have to go by way of civil claim, meaning you have to obtain a judgment in court. Yeah, these are the procedures when it comes to unsecured debts. The usual procedures that we do is we issue a letter of demand, then we file summons in court. Then if there is an appearance, then we go on hearing. Hearing, you can get a summary judgment. If there's any dispute, you go to trial. If there is no appearance entered, then you'll get a judgment in default. Eventually, the bank recourse is we have to get a judgment first. When you get a judgment, if let's say after we get a judgment, the judgment debtor, meaning the defaulter, still refuse to pay the judgment sum in accordance with the judgment, the next step that the banks will need to consider is to enforce the judgment. Then there are various modes of executions that I just pick out 4, which is the most common one which can be done by the bank. Yeah, I will just go through one by one shortly. Yeah, there are various factors when it comes to enforcement of judgment. Yeah, when you get a piece of judgment, so the next thing is that if the judgment debtor still refuses to pay, then the bank will need to consider certain factors below, like which is the most effective mode to enforce the judgment. So factors such as the cost, the time, whether you understand your debtor, whether the debtor is having any valuable assets, whether the debtor is having, any other bank's accounts with other banks, any monies, with all these things, when you analyze, then the bank will decide which are the most effective mode to recover the sum of money. Let's go to judgment debtor summons. This mode may no longer be so practical nowadays, because judgment debtor summons is when the debtor has to be brought to the court by summons. So usually you have to, by way of personal service, serve the summons on the debtor itself. Then the debtor has to be appealed before the court and to be examined under the oath. So at this time, the court will examine the individuals, whether they have any bank accounts, any assets, properties, and all that. And from there, the court will access and make an order for the debtor to pay the debt. So it can be by installments, and it can be a very smaller amount every month, or in whatever manner that the court thinks is reasonable. Whereas read and schedule and sell, it happens when an application to court to seize the properties, the charters, like the personal below, the things, the movable, immovable assets, which is owned by the debtor. So what we do is the court will give an order for the court bailiff to seize the valuable items by giving an inventory list with the value of the items. From there, those items can be sold by way of public auction. So for this mode also, the proceeds, usually, like you see, usually when we go on read and schedule and sale, the bank must identify that the borrower or the company itself, it owns a valuable assets. Otherwise, if you're imposing this mode and you get the bailiff to go and seize all the items on the spot, the bailiff will give the value, the amount and the value of the items, and go for a public auction. So you have to judge whether this option is worth for the banks to tap. If let's say there is a valuable properties, if there is none, then this mode may not really be useful to the bank. To me, the most effective way that the banks for recovery is garnishee proceedings. Garnishee proceedings is particularly useful if you have a knowledge that the debt owing to the judgment debtor by a third party. Let's say if you are aware that there is a bank account maintained by the debtor with any other banks, or let's say you are aware of any other third party, they are owing any money to the judgment debtor. At this manner, you can actually garnish the amount from the third party, or you can garnish the amount in the debtor's bank's account maintained with other banks. So how does it work? Usually for garnishee proceedings, the bank will do some, and the bank can actually trace from their previous record any disclosure made by the judgment debtor, whether is there any bank accounts that this borrower is maintained with. If you are aware of any bank account that this borrower is maintained with, you can actually get an order to order the holder of the money. Meaning, if let's say the borrower is having a bank account with any ABC third-party bank, you can actually garnish, serving a garnishee order to show cause to that bank account in order to get to earmark the saving account or to earmark any account of money that is maintained with the ABC bank. So the ABC bank, instead of paying the money to the judgment debtor, it will pay direct to the judgment creditor. These are few examples that we can do is can apply to take money from the judgment debtor on source of income, or if there is any contracts entered between the judgment debtor with any other person or entity, the judgment creditor can garnish the income and direct the payment to the judgment creditor instead. Or lastly is the most common one, to garnish the judgment debtor's bank account. So this is all applications is made to the court to take the money in the debtor's account to repay the judgment debt. So for garnishee also, I just draw a chart. Yep. Usually once a judgment has been obtained, the judgment creditor can file an application in court to get a garnishee order to show cause. So if you are aware of any bank accounts that the judgment debtor is maintained with, you can actually serve the garnishee order to show cause to the third party bank. And once the third party bank receive the garnishee order to show cause, what they do is they will either freeze the account or they will earmark the garnished amount. If the amount is insufficient to pay off the judgment sum, they will earmark the total sum in the bank account itself. If let's say it is sufficient to repay the judgment sum, usually they will also earmark the garnished amount. At the same time, there is no, there is no law under the rules of court that they must freeze the account. So every different bank may have different procedures in handling when they receive the garnishee order to show cause. But what they have to do is they have to earmark the amount. And thereafter, upon the hearing date, they have to produce the amount earmarked, and the court will make a garnishee order. The court will make a garnishee order stating that how much is the amount that the garnishee has to pay to the judgment creditor's bank. So instead, the money based on the court order, the garnished amount will be paid direct to the judgment creditors to settle the judgment sum. Yep. So under the garnishee proceedings with the court order, the banker is permitted to disclose the details of the judgment debtor account so garnished. These are allowed under the permitted disclosure under the Financial Services Act. So if the earmark amount such payment by the garnishee did not dispute the debt, it is a valid discharge of its debt due to the judgment debtor. So the next one is the usual that we heard about bankruptcy proceedings. Yeah. Bankruptcy proceeding, the threshold has been increased to make up petitions for someone to be adjudged bankrupt. The threshold now is 100,000. So this is a popular option if you are aware that the person is actually having money, but then it just refused to pay. So you may apply a lot of pressure to the individual borrower so that they will not be adjudged bankrupt. But bearing in mind, if let's say in terms of bankruptcy proceedings, if the debtor is adjudged bankrupt, there is still a very lengthy and long process. It's not that once he's adjudged bankrupt, then whatever money that he has to be paid to the bank direct. Because all monies, once a person is adjudged bankrupt, all his power, all the monies will be actually vested with the insolvency department. The insolvency department will call for the creditors meeting. After the creditors meeting, they will assess the debtors, what are the capability that the debtors can pay every month, and also taking into consideration whether there are any priority, the secured creditors. So you have a priority in making repayment. So bankruptcy proceeding, or the next one I talk about is the winding up proceedings. When you are going to wind up the company, the process are still the same. So after you get the winding up order, also you have to file your proof of debt and all that. The insolvency department will call for the creditors meeting. So be it for bankruptcy or winding up, it will be effective if you are aware that the individual, they still have the financial capability to repay, then you may give a pressure for the individuals in order to force him to repay. For the company, for the winding up petition, it is effective if you are aware that the owner of the company do not want their company to be wound up. So if that is the purpose, then I think it serves the purpose. Otherwise, it's actually a lengthy process. At the end of the day, we still wouldn't know whether you can get back your judgment sum. So I just give a brief summary about all the moods. Yep. So when it comes to recovery of unsecured debts, 就是借款是无担保的情况下呢，如果是借款是无担保的情况下，那根据马来西亚的法律，你就得去做这民事法庭民事诉讼拿一个裁决。当然拿到裁决了过后呢，下面它有很多的这个拿到裁决过后，这裁决只是一张纸。那拿到裁决过后，下一步我们就想要怎么样执行？要怎么样执行的话呢？因为它有不同的执行方式，所以债权人就是这个 judgment creditor 需要考量整体这个债务人，就是欠债人的财产，他的动产、不动产、时间、律师费等等，要想出最有效能够追讨回这个债务的这个裁决执行方式。所以以下的裁决方式呢，都是现在最普遍跟最常见的一些裁决方式。当然第一就是这个 judgment debtor summons， 它是一个裁决债权人传票。这裁决债务人传票呢，就是欠债人是得要通过法庭给的一个法令，他得出席法庭，然后他会在出席法庭的时候告诉法官说他现在现有的资产是什么，他每个月的收入是多少等等，然后由法院决定，可能只是每个月可以他就是批准，他一个月只需要还很小的数目。所以在这个 JDS 啊，就是裁决债务人的传票来说，它未必是最有效，能够在银行追溯这个欠款的时候未必是最有效的。然后下一个是这个 writ of seizure and sale， 它是一个扣押和这个变卖、扣押出售的一个 扣押出售令。所以这边呢，可以向法庭申请一个扣押令，扣押这个债务人他的动产和不动产，扣押了他的动产跟不动产之后，过后就可以做出变卖，然后变卖了过后的那些变卖过后的，其实收到的钱呢，还得要先支付这个法庭派出的法警，因为法警会负责做变卖的工作，他会先将所有这些其他的费用都先还给法警，还给法庭过后呢，最后的那个 balance， 最后的那个剩下的才会分回还给这个债权人。所以下一个是我们的 Garnishee Proceedings。Garnishee Proceedings 是一个第三方债务人的法律程序。Garnishee Proceeding 呢，就是向法庭申请锁定这个债务人，他可以寄放在其他银行的存款，或者是他的一些 bank account， 他的存款，他的银行的任何你知道他有银行，还是要有其他合同，就是如果是你知道他在其他的银行有其他的这银行户口的话呢，这个程序是可以在不需要这个债务人的同意，不需要债务人的在的情况下，你可以直接拿一个停令。拿到这个停令的时候呢，第三方的银行就得将那个存款，就是这个欠债务人的存款直接还给这个 Judgment Creditors， 就是债权人。所以这个 Garnishee Proceedings 在银行的角度来说也是最常见，跟最多银行觉得是最有效的一个执行裁决的方式。下一个 Bankruptcy Proceedings or Winding Up Proceedings， 它就是一个个人破产或者是公司清盘的一个方式。但个人破产跟公司清盘的方式，其实就算个人破产了还是公司清盘了，它也未能达到，就是银行可能也收不回你欠款的那个数目。所以在个人破产或清盘它有效的情况下，是因为如果那个人本身其实是有能力偿还，但他先不想偿还，或他 refuse， 他拒绝偿还的情况下，在这个个人破产的一个方式会让他施加他的压力。所以在那压力的情况下，他为了就是不让自己破产，所以他会偿还。然后一样，清盘也一样，因为清盘来说，如果你清盘一间公司，你过后还需要结算，结算了你还需要发你的 proof of debt， 然后到时你还需要叫所有的那个债权人一起过来，然后有 meeting， 所以它是一个很长的一个 process。所以清盘它会有效，如果那间公司是真正想要营运而不想被清盘的情况下，那个 Winding Up Proceeding 是有效的。So that marks the end of our sharing sessions. If any questions, you can just post to a quick Q&A chat box here, then we will answer it.
Thank you to both our speakers for the enlightening sharing. I'm sure it is very helpful to many, especially our attendees today. Now we have come to the Q&A session for this webinar. You may post your questions in the Q&A chat box if you have any questions. We have here a few questions from the attendees. The first question is, if I lodge private caveat on a property under National Land Code, can the bank still auction my property?
Anshan, I think I'll answer these questions. Okay, if you have lodged a private caveat under the NLC, so I would like to know who is lodging. If you have a caveatable interest, you can lodge a private caveat on the property. But if let's say the property has already been charged to the bank prior to the lodgement of private caveat, so the banks are still the rightful chargee. So the banks still have right to auction the property. So if there is a private caveat over there, the bank can always get the court order to remove the private caveat lodged. So the priority is that if let's say the caveat was lodged after the charge is in priority, so the bank was still entitled to auction the property. Yeah.
The second question is from Daniel Sik-Ting Yue. Also, the question is, can we proceed with the legal actions against borrower and guarantor simultaneously in the event the borrower has defaulted the loan payment?
Yes, you can. To save time and to save costs, usually you can do that because when there is a default by the borrower, what the bank can do is issue a letter of demand against the borrower and the guarantor simultaneously. Your actions is always cumulative, so you can do at one time without waiting, so you can.
Okay. The second question is also by Daniel. What are consequences if the bank ignored garnishee order to show cause served to the bank and did not earmark the garnishee sum in the defendant's account? Further, how many times can the bank earmark the money in the defendant's account?
The first part of the questions, I believe the bank I believe under the bank system, if you are answerable, accountable, or compliance to Bank Negara Malaysia, and also when there is a court order, I believe none of the bank can ignore a garnishee order to show cause. If let's say there is really omitted on to attend the hearing itself, the bank can usually request to provide an further affidavit in support to produce the earmark amount. I believe there is no way that we can actually ignore, the bank can ignore a garnishee order to show cause. If there is really the bank ignore a garnishee order to show cause, I think it amounts to a committer. It's a serious consequences. I don't think it can be done. Yeah. So my second question from Danny is, how many times can the bank earmark the amount in the defendant's account? You just need to earmark. Okay, when you get the garnishee order to show cause, then you will know how much is the judgment sum. On the day you receive the garnishee order to show cause, you will already earmark the amount. It's either you freeze the account. If you don't freeze the account, you have to earmark the amount. Then if let's say the procedure is that you get the lawyer or you provide your affidavit stating the amount that has been earmarked, you file in your affidavit. So that is one time you earmark. If let's say there is any money that keep coming in from that account itself that you already garnish or earmark, if the bank happens to be unfreezed, did not freeze the account, so there are still monies coming in prior to the hearing date, meaning prior to the garnishee order absolute, prior to the hearing date, if there is any money still coming in, you still can put in your further affidavit to earmark the amount. Yeah, if it happens so until the hearing date, until you get the final order, the garnishee order absolutes, then there is no way you can change the amount. So how many times you earmark, it has to be before the hearing date. On the hearing date itself, when the court giving a garnishee order absolute, that will be the final amount. Yeah, I hope I answer your questions, Daniel.
Another question from Kenneth. Garnishee order is applicable to safe deposit items, example like gold bar, or only bank account money?
Garnishee order, when it comes to garnishee order, it has to be a monetary term. So if your gold bar is actually those gold bar that you kite in the bank safe deposit, it cannot be converted. At that point in time, it cannot be converted into the monetary term because the bank officer will not going to take out the gold bar and convert into a monetary term. What they will do is from your accounts, from the banks, from your savings account, current account, or any accounts that you maintain with the bank, that will be the monetary term. So that when it happens to garnishee order, it will only go with your monetary kind of things. But when it comes to gold bar, you can go for other mode of executions like WSS, the read and schedule and sale, because it amounts to your properties. So it's other type of mode. Yeah, garnishee order is only applicable to bank account money.
Any more? I believe that's all the time we have today. This marks the end of our webinar. Thank you very much for joining us.
Thank you for joining us today. I hope you find our webinar informative. Thank you, everyone, and please stay safe.